here. All right, I'll start over. Again, the time is now 10:02, and I will call the meeting of the District of Columbia Board of Ethics and Government Accountability to order. My name is Tamika Collier. I have with me Shamari Wade, Norma Hutchinson, and Darren Sobin. We constitute the sitting members of the board and therefore do have a quorum. Before I start with the business of BEGA, I want to acknowledge that this is the last meeting for Board Member Wade. Thank you for your service, your insight, counsel. I'm sure other people will have things to say, but we will have cake and presentation of your clock after the board meeting. Moving on.
The clock was supposed to be a surprise, by the way. Just because every one of us have gotten one when we left, it doesn't mean he was necessarily going to get one too.
Right. Your clock is special. Going back to the agenda, I turned to the January 10th, 2018 meeting minutes. And before I call for a vote on them, for the full board's purposes, I'd like to get an understanding as to why they are amended meeting minutes and the process that went through and that is currently in place to post these meeting minutes.
Yes, Madam Chair. The meeting minutes from the January 10th board meeting were based on one of our staff members' notes in combination with our own internal notes of what we plan to say at the meeting. There was a misunderstanding by the staff member regarding exactly what was said during the meeting, and the minutes were posted to the website based on her recollection and her notes, as opposed to comparing our notes and recollections with what was actually said and recorded during the meeting itself. And so we had to retract those unapproved minutes and amend them to be consistent with the oral recording of the meeting. And so moving forward, before we post any minutes, even in an unapproved status, we will compare our notes and recollections with what was actually recorded to make sure that human beings, we have imperfect memories, to make sure that what we think we heard is what we actually did hear.
I'll give the board a few seconds to look at the meeting minutes. All those in favor of approving the corrected January meeting minutes, please signify by saying aye.
Aye.
Any opposed? The meeting minutes have been approved. Next, we will turn to the report from Director Allen. Good morning.
Good morning, Chairperson Collier and members of the board. I am Nikel Allen, Director of the Office of Open Government, and I am pleased to present this monthly report on the activities of the OOG. The OOG has continued to fulfill its mission of ensuring that all persons receive full and complete information regarding the affairs of the district government and the actions of those who represent them. I would like to start by thanking Board Member Wade on behalf of the OOG for your service to the District of Columbia, and note that it's been a pleasure working with you. Thank you very much. You're welcome. Respecting advisory opinions, on February 6, 2019, the OOG issued a FOIA advisory opinion in response to a FOIA requester. The advisory opinion addressed what notifications, if any, does FOIA require an agency, specifically the Metropolitan Police Department, to provide a requester when, one, it invokes an extension to dispatch the termination to a FOIA request for body-worn camera recordings, and two, when no determination is dispatched by the agency to the requester within the applicable period, what should MPD do? In this matter, MPD failed to follow the FOIA law by failing to inform the requester that the delay in responding could be construed as a denial of the request and not providing notice of the requester's appeal rights. OOG recommended that the MPD General Counsel create a form letter that comports with FOIA law that MPD should send to requesters seeking body-worn camera footage. OOG also advised that MPD should provide the requester with a determination or provide a letter to the requester that provides the proper notice and information required under FOIA law and regulations.
Have you had any response from MPD?
Not yet, but I plan to follow up with them just on this issue. In general, we have received a lot of feedback from the public about body-worn camera footage and MPD's processing of that. So I would like to have a meeting, probably with Terry Ryan, to find out the status of the issue and what MPD is doing with respect to processing these recordings.
Okay.
While you were going through this process, were you collaborating with MPD with respect to information and policy?
Johnny Barton, our attorney, was communicating with MPD staff throughout the process in the course of his investigation about what happened with this particular FOIA request. He was not dealing with the general counsel staff, but with the FOIA officers who are different, and that would be Inspector Vendette Parker, who is the MPD FOIA officer.
And did you find them cooperative?
I can let Attorney Barton respond to that. Johnny?
Were they cooperating?
With me?
With you.
Correspondence, yes.
Good. I thought it was a well-written, well-reasoned opinion. It struck the right tone. It was balanced. It gave guidance. And so I like it. You haven't heard back from the general counsel yet?
No, not yet. But I'll follow up with the general counsel this week, well, today or tomorrow.
Good. Well done. Thank you.
Thank you. Second, informal Open Meetings Act and Freedom of Information Act advice. Since January's board meeting, the OOG has responded to 8 FOIA and 4 OMA requests for substantive advice and 2 requests for technical Open Meetings Act advice. The next matter is OMA and FOIA audits. The OOG provided notice of its planned comprehensive FOIA OMA audit to the Mayor of the District of Columbia on January 31st, 2019. The OOG will provide written notice to the Attorney General and independent agencies of its planned comprehensive FOIA and OMA audit on or before Friday. OOG plans to complete the audit before August 1st, 2019, and will report the results prior to the close of the fiscal year. Training and outreach. On January 10, 2019, the director attended the Open Government Advisory Group meeting. At that meeting, the Chief Data Officer, Barney Krukoff, provided a review of the 2018 Open Data Report and will present the 2019 Open Data Report at the next meeting, which is this afternoon at 4 o'clock. The Office of the Chief Technology Officer also provided an update on its efforts to define and protect public identifiable information in the district. The OOG director plans to meet with OCTO in the near future to discuss this issue. On January 17, 2019, the director attended the Open Government Coalition meeting. Prior to that meeting, I met with a small group to discuss body-worn cameras and concerns regarding MPD's processing of FOIA requests concerning body-worn cameras. As you may know, MPD utilizes a third-party vendor to process body-worn camera videos. This vendor makes redactions to the videos, basically blurs out parts of the video.
At MPD's request.
At MPD's request, yes. The discussion concerned the cost of processing this request and the amount of redactions that occur prior to the release of videos. The group presented me with some of the videos they received where faces, numbers, license plate numbers were blurred out. Their concern was that the redactions diminished the value of the videos and the cost of the video redaction was quite high. As a result of this meeting, OOG is considering hosting a roundtable or other forum regarding body-worn cameras in the near future. OOG was also invited to participate in Sunshine Week as a speaker or panelist by this group.
Excellent. So regarding the roundtable, I think I've read publicly, but do you have any insight into MPD's position regarding the redactions? I know part of it is privacy, part of it is ongoing investigation.
Right.
But what is their position, and how would a roundtable impact their position, or would it change at all?
With respect to the first question, again, it's to protect the integrity of the investigation, so revealing officers' faces and badge numbers, et cetera, in the course of an ongoing investigation would fall under the FOIA exception, which is why they have made those redactions. As far as a roundtable, the Open Government Coalition seemed to think, and I agree, that the district revisiting this issue and just discussing it would be, a good idea, just for the public as well as MPD to kind of brainstorm and communicate with one another to find out where the problems are, and to look at other jurisdictions and look for potential solutions. I think the district is at the forefront with body-worn cameras and has done a good job. I think this is just a wrinkle in the process as we, as a city, figure out how we're going to continue to process these requests and the cost, and whether just looking at those issues to try to find out what works and if the cost outweighs the benefit in those types of issues. So as far as changing MPD's mind, I'm not sure that a forum would do that, but I think it would just give an opportunity to open up discussion on the issue and figure out where we are with it as a city.
Yeah,
So,
I think it's a good opportunity.
I mean, we do want to be sensitive to the concerns of the open government folks. So what is it that you've heard that they really have a problem with? The blurring out of license plates? Is that an issue?
Well, when you spend all this money for the video and then you get something back which really is useless, I think that's kind of a concern, that perhaps they should tailor their requests so that it provides the information that they're looking for.
The stuff that's coming out now, that's coming out based on the authority of rules, right? MPD has rules that says what they're supposed to take out.
Correct.
And so are the open government folks suggesting a change to the rulemaking?
They have not suggested that. It sounds more of a communication between the two. They have suggested that MPD should have policies and procedures that are available to the public so they can get insight into the charges that this private company is charging for the redactions and what the cost is per hour, like the cost breakdown. That information is not provided. It's just been a raw number, so they're curious about those types of issues.
So when did the outside company start doing this? Because I remember it wasn't too long ago that they were doing it in-house.
Right.
In fact, I knew the guy who was doing it.
Okay. I can find that out. I'm not sure the amount of
And
time.
so now that they're using an outside company, the cost of redaction and releasing the video has gone way up?
Yes. Correct.
Substantially.
Yep. Okay.
So, okay.
Thanks.
I will keep the board informed on this issue once I get more
this
information.
really may be an issue between the open government folks and MPD, not us.
Right, but we have a stake in assisting with making sure that it's transparent, and I think we can serve as a facilitator of discussion between the two.
Sure. And if the council sees fit to help MPD cover the costs of redaction, that might be an option as well.
Okay. Thank you.
Thanks.
Okay, on January 17, 2019, I met with counsel for the Committee of the Whole to discuss FOIA. As you know, the Judiciary Committee of the D.C. Council still has jurisdiction over BEGA, and now the Committee of the Whole has jurisdiction over FOIA. From my discussion, I gleaned that if there's any legislation concerning FOIA, it will go to the Committee of the Whole. The purpose of this meeting was to introduce myself and provide information concerning OOG's role in the FOIA process. And I think the meeting went very well, and I was glad to get that line of communication open. On January 29th, I, along with Director Wolfenbarger, participated in a conference call facilitated by the Mayor's Office of Talents and Appointments to establish a training schedule for members of boards and commissions and board administrators to receive Open Meetings Act training. The schedule has not yet been finalized, but training is anticipated to begin this month. OOG will provide an hour-long training for board administrators and a shorter training for board members.
Excellent.
On February 1st, 2019, OOG Attorney Johnny Barton provided a FOIA and OMA presentation for the Academy of Public Administrators of Kazakhstan. On February 6, 2019, I attended the Open Government Advisory Group's FOIA OMA subcommittee meeting. At this meeting, we discussed the growing public concern regarding the records of individual charter schools being available to the public. I provided a February 4th Washington Post article for the board's review regarding D.C. public charter schools and transparency. And this is not the public charter school board, but the concern is about individual public charter schools. I also informed the group of OOG's rulemaking that will be published in the near future. And moving on to the rulemaking, the Office of Open Government has submitted for consideration by the board new and revised regulations to implement the recent changes in the law and which make clarifying amendments to the OOG's regulations at 3 DCMR Section 104000. We have provided a copy of the proposed regulations for your consideration, which we worked with the board's senior attorney, Ms. Ford, and she provided valuable insight and was very helpful during OOG's revision process. We estimate that we'll submit the proposed rules for publication in the DC Register next week, pending your comments. And lastly,
can you give us a couple of highlights of the changes? Because honestly, I didn't get through them all.
Okay.
And even when I read through them, I didn't know what was being altered and what was not.
The main part is setting forth rules for the appeal of advisory opinions that the Office of Open Government issues, so the board is able to, I guess, have a second bite at the apple. So we have that.
Okay.
We also provided some guidance regarding rules of parliamentary procedure. That's new, and those are the main, I guess, two changes. The others are just making the rules more readable and relevant based on comments and feedback that the office has received from the mayor's office and the public and others.
And I know we're not required to do this, but did we happen to run this past our friends at the Attorney General's office?
We did not, but on your recommendation, I will make that happen.
The Legal Counsel Division is adept
yes.
rulemaking review, even if it's just for typos. Not that I saw any in here, but
better
still,
safe than sorry.
They have 50 years of experience.
Yes.
Doing this.
Thank you for that.
Thanks.
On the Robert's Rules of Order point, I think you used the term should, which is not must.
Right.
But with that, how do you propose to help the boards and commissions follow that? Are you going to offer training or maybe put out a manual, something more to help them implement? Because we don't even, I mean, we loosely follow
right.
it, but we don't. And it might not be necessary for very simple votes and can get very complicated with amendments and points of clarification. And it might depend on the level of sophistication of the board as well. So how do you propose to help the boards and commissions follow that should?
We'd like to provide a training course on Robert's Rules of Order, possibly hiring a registered parliamentarian to provide that training. I'm now studying to become a registered parliamentarian, but I am not there yet. So I'd be more comfortable having a registered parliamentarian providing a training. That's something we could do here. I would assess the interest and schedule some courses. I think having a manual is a good idea. So I will look into putting that together.
And this is something, thinking ahead, that the new FTE could also
Right. I'm hoping
specialize
that person
in
could be a
as
registered
well.
parliamentarian. Right. Okay. And lastly, staffing. The announcement to fill the IT specialist position is closed. We're currently reviewing the resumes submitting in response to the vacancy announcement, and we'll schedule interviews for the position this month.
And what are you doing for IT support until the vacancy is filled?
Relying on Octo, and Octo helps in the interim. We have not had much come up, so we've been very fortunate. And again, I have enough IT knowledge to be dangerous, so I'm able to do some things
I
myself.
For the purpose of the board, we have had this conversation, but I want to put it out publicly for them. There has been no change in policy about posting the audios for the meeting minutes.
That's correct.
The reason that they weren't posted for December and January immediately following was because the lack of IT support.
Correct. And they are on the OOG website now and also on the BEGA website. And I will be making those edits to the meeting today myself, and hopefully we'll have those up early next week or provide them to Director Wolfenbarger to make sure they're on the BEGA site as well.
Okay. Thank you for that clarification.
You're welcome. This concludes the OOG Director's Report for February 7th, 2019. Thank you very much.
Thank you.
Thank you, Madam Chair. I'd like to join Director Allen in thanking Board Member Wade for his service. I've been here about a year, a little more than a year, and your judgment, wisdom, and guidance has been greatly appreciated, so thank you. Report by the Director of Government Ethics. Update on our operations. These reported statistics do not reflect status changes that we anticipate will occur as a result of actions taken by the Board during today's meeting. Open investigations by status. We have 25 open and active investigations. We have 3 investigations that are open at the show cause hearing stage, and we have 3 investigations that are open in the negotiation stage for a grand total of 31 open investigations. Pending stayed investigations by status, we have 11 that are closed pending collection. We have 1 that is closed pending appeal to the D.C. Court of Appeals. We have 2 that are closed pending D.C. Superior Court Appeals, 2 that are stayed pursuant to the Attorney General False Claims Act cases. 5 are stayed pursuant to OIG investigations, and 3 are stayed due to U.S. District Court cases, for a grand total of 24 investigations that are pending or stayed. Regulatory matters by status, we have 27 that are closed pending collection, 1 that is open, 2 that are open on appeal to the Director, and 1 that is open on a board appeal, for a grand total of 31. Looking back historically over the last 3 months, our numbers have remained remarkably stable. We had 31 investigations open the past 2 months, as well as here in February, and we also had 10 that were stayed and inactive. So even though we've been opening and closing cases, numerically they've been staying pretty consistent. Publication and reporting obligations. We are in the process of completing the quarterly complaint report for the first quarter of fiscal 19. As mentioned last month, although we did not adopt any new performance measures for fiscal 19, we have identified new statistics related to our regulatory enforcement matters and audits that we will report in fiscal 20, and we have begun to keep track of those statistics during fiscal 19 to use as a benchmark for comparison purposes next year. Additionally, our performance questions from Council, our answers are due February 11th. and our written testimony is due February 14th in anticipation of the hearing on February 19th. The rough draft copy of the responses was uploaded to the board's Dropbox for your review. Trainings and outreach. We had no trainings and outreach attended by staff in the past month. Conducted by staff since the late of the last meeting, we conducted or participated in 4 trainings, which was 2 more than the 2 we concluded the previous month. The 4 trainings consisted of 2 new employee orientations, a monthly training session, and a training session at the Office of the Attorney General for new members. There were also 2 lobbyist webinars conducted by Octo on our behalf. On Friday, February 1st, we hosted a delegation from Kazakhstan. One of their questions pertained to whether unexplained displays of wealth on social media triggered an automatic investigation by our office. Apparently, that is a significant problem in their country, in part because civil servants typically are not permitted to have outside employment. It was explained that here in the district, employees could have outside employment or wealth obtained legitimately from other sources, but that we did not use social media in some of, but that we did use social media in some of our investigations.
Certainly nothing precludes us from receiving evidence from any source to trigger an investigation.
Absolutely, absolutely. Also, there is a board and commissions training coming up on this coming Saturday from 11:30 to 1 that I will be participating in.
Director Allen, are you participating in that one?
I wasn't certain it had been confirmed yet.
It's my understanding that it has been, but I can follow up just to make sure.
Okay, then yes.
Okay, I just want to make sure that they are utilizing.
Yes, that 30-minute presentation that I referenced.
Okay.
Yeah, I believe Mr. Flowers is correct that there are some of these trainings that they're having where OGE and OOG are not necessarily overlapping and participating in the same meeting. So it's entirely possible that this is one OGE will be at, but OOG is not supposed to be at. Newsletter. Due to other pressing deadlines, we postponed publication of our next newsletter until later in February. Also, on the outreach angle, we are organizing the road shows. We circulated a spreadsheet of all of the ANC's regularly scheduled meetings, days of the week, time, locations, and the plan is for us to begin conducting those jointly with OOG about 3 or 4 per month. And if we can do that within the course of a year, we should be able to meet with all of the ANCs. And we are also open to other community organizations that may have an interest in learning more about our operations.
Excellent.
Advisory opinions and advice, informal advice, approximately 67, which is higher than the 39 reported at the last meeting. It should be noted that a number of these advice inquiries were related to the new lobbyist filing platform and do not include the inquiries handled by staff other than the attorneys addressing those questions. Formal advice requests, we have 1 pending formal request for post-employment advice.
Is that the same one from last month?
It is not. The one that we talked about last month, we have, I believe, finalized the letter. I sent the final version to Ms. Ford yesterday afternoon, and it's ready to go out. The pending request for advice is from ABRA. It's not from a DCRA former employee.
Oh, okay. I didn't realize they were separate because the ABRA is also dated summer of 2018. I'm getting at how long you're keeping.
Correct.
So it looks like there are at least 2 formal opinions that have been sitting with your office for months.
Apparently so. And that is not something that I'm particularly proud of.
The one that was discussed at the last meeting is about to go out.
Correct.
And we are addressing the second one today.
Yes, there's a the one that involves the one that involves an ABRA employee is a matter that we will take up with the board during the executive session.
Okay.
Ethics legislation, comprehensive code of conduct. We are anticipating that Councilmember Charles Allen will introduce the comprehensive code of conduct this council period. Rulemaking. We have prepared a proposed rulemaking for your consideration that modify existing procedures and establish new procedures to govern the processing of some of the regulatory appeals we handle, including FDS filing waiver requests, FDS fine waiver requests, and lobbyist penalty waiver requests. The rulemaking includes conforming and technical amendments that were identified when we last reviewed our rules in 2016. Our intention is to publish the entire body of our rules to ensure that they are in one location and easier for the public and interested persons to find. We ask that the board approve this proposed rulemaking subject to modification by the General Counsel if needed to comply with the technical and compliance requirements applicable to the rulemaking process. Budget. The data and document migration process for our new case management system has been completed, and all historical case data and documents from ProLaw have been imported into CMTS, except for 213 so-called events that were created within ProLaw to note certain case developments as milestones, such as the issuance of an order by the board, that in most instances were also memorialized by digital files such as PDF scans of the actual digital order. We are still working to get the contents of those events extracted from ProLaw and imported into CMTS as files associated with their respective cases, but the overwhelming majority of those events are related to closed cases and have no bearing on OGE's open investigations. However, I did want to let the board know that the new case management system is fully operational now. I also wanted to update the board on our efforts to secure additional space for the agency that would allow both offices to be housed together. I've exchanged emails with the Chief Operating Officer for DGS, Mr. Fuller, regarding our interest in moving to a discrete space on the 7th floor where OCP's IT department historically has been housed, that we have been told may be large enough to accommodate both OGE and OOG. Mr. Fuller has tasked the Associate Director for the Portfolio Team at DGS, IMO, with following up on our request. But unless DGS can locate additional space for BEGA at 1 Judiciary Square, it is our understanding, based on prior conversations with Mr. Fuller and others at DGS, that DGS generally does not act upon an agency's request for additional office space unless and until the interested agency can identify funding that is available to pay its rent expenses for such space. And we have submitted a budget enhancement request for fiscal 20 that I'm sure we will be discussing with the council and the mayor's office in the upcoming months.
Yes.
How much is that for?
It's about almost $400,000. It's like $398,000 for the first year, and then it jumps up to $410 probably in year 2.
And how'd you arrive at that amount?
DGS conducted a study. DGS brought a consultant over, met with us, looked at the existing space that we had, talked about our needs, and determined that while we have about 3,100 square feet right now between the 8th and 5th floor, we really need somewhere between 7,000 and 8,000 square feet. And so they gave us a figure based on a per square foot basis with a certain percentage increase in each future year.
And so that number is based upon what it would cost us if we were to rent commercial property?
Correct.
And they wouldn't charge us, though, if it were a district-owned building?
It's my understanding that I've heard that they don't, but I've also heard some agencies indicate that they have been charged rent. I don't know exactly what the truth of the matter is. I just know that we've been fortunate historically that we have not been charged rent for the space we've occupied here, and therefore we've not had any money budgeted for that purpose.
Based on the oversight hearings last year, there are agencies who occupy district-owned buildings who pay rent.
I've heard of that also.
Yes.
I just didn't know what the standard is.
I'm not sure that there is. It may be grandfathered agencies, and we've been flying under the radar with this space here. So, I mean, I don't know how convenient it is staff-wise, but fiscally, it's much better if we stay here, even if you have to sacrifice a few square feet. My understanding is the report that was done was based on space for evidence lockers and additional space for FTEs that we don't currently have, but anticipate having in the future?
Correct. There's a little bit of cushion built in for possible expansion of FTEs in the future, but primarily it was based on DGS's own space requirements for the amount of square footage an employee is supposed to have in their workspace. When you look at the cubicles that we have in the bullpen, they're significantly smaller than the minimum amount of space employees are supposed to have to work at. So I think that DGS, the consultant, recognized those issues with our current space and addressed them accordingly.
Now I know why I got those cubicles so cheap.
Okay, staffing. I would like to introduce you to our new compliance specialist. Okay.
Hi.
This is Andrea Blaine. Ms. Blaine comes to us from the Department of Behavioral Health, where she served in a program specialist position as the executive assistant to the agency's chief operating officer. Prior to her service at DBH, she was at FINRA, where she gained experience working with their case management system, arranged logistics for hearings and pre-hearing conferences, and prepared documents related to FINRA's disciplinary proceedings. Prior to moving to Washington, D.C. in 2015, Ms. Blaine spent 10 years working at a hedge fund called Titan Advisors, LLC, in Stamford, Connecticut, where she worked her way up to serving as the executive assistant to the firm's president and gained experience providing high-quality customer service to the company's investors, a highly exacting customer base, to say the least. She earned her bachelor's degree from the State University of New York Purchase and is currently pursuing her master's degree in human resources management from the Catholic University of America, and we are very happy to have her on board.
Welcome, Ms. Blaine.
Welcome.
On a down note, I am sad to report that our auditor, Ishmael Okai, resigned his position a few weeks ago, and his last day with us was Friday, February 1st, 2019, to accept a job closer to his home in Virginia. We have already secured DCHR's approval of a new position description for a grade 13 auditor position that is more agency-specific than the one that was previously in effect, and DCHR should be posting that position for application within a few days if it hasn't already been posted.
And what's the plan to handle his responsibilities until the new person is in place?
More than likely, we'll be dividing that up amongst, I'll be taking the lead primarily. We'll probably have Andrea take a look at some of that, because the way I envision that audits working moving forward is kind of hand in hand with the compliance specialist. And to the extent that we need any additional assistance, I may reach out to some of the attorneys. But the plan is to get this filled as quickly as possible. Litigation, status of pending cases. Garen Price, this case was submitted on October 24th, 2018, and we are awaiting the court's decision.
It's in the Court of Appeals?
I believe so. Lobbyist financial disclosure matters. On Tuesday, February 5th, 2019, we distributed the annual agency head memo to approximately 90 ethics counselors. As you know, the agency head memo kicks off the financial disclosure season. We included with the memo several relevant documents and templates, including the ethics counselor financial disclosure manual written by Attorney Stuart Mitchell. We scheduled 3 ethics counselor FDS trainings for next week. Ethics counselors can sign up for the training via Eventbrite, and so far 15 ethics counselors have signed up. At our internal FDS meeting last week, we discussed the general strategy for the FDS season, which includes returning to paper notifications and increased communication with Octo. We still have approximately 200 PFDS non-filers from last season. We will begin formulating a strategy for conducting enforcement and bring that strategy back for discussion with the board in the coming months. Along that same vein, we'd like the board's input on enforcement of assessed fines against individuals who are no longer district employees. We need to adopt a uniform process for collecting fines from those who have left district employment, and we'd also like to put definitive deadlines in place for the end of each FDS season, including all waiver requests and fine enforcement.
What's your recommendation? Are you looking for input right now?
I don't believe so. I mean, but we've discussed some of these things at the board's meetings in the past, stopping short of initiating civil action, but kind of acting like a bill collector, like a medical office that hasn't been paid for services rendered. When we have fines that are not collected, reporting that information to the 3 federally recognized credit bureaus to serve as an additional incentive for repayment of the fines. Financial disclosure waiver request pursuant to DC official code 1-1162-21A3. Anyone adversely affected by a civil penalty may appeal said penalty to the ethics board. We currently have no financial disclosure waiver requests pending. Lobbyists, lobbying program. We have a meeting with Octo next week where we will discuss early prep of the FDS e-filing system and work on a game plan to implement several system enhancements to the lobbyist system that our customers have recommended. I am also planning to schedule a meeting with the new Chief Technology Officer to discuss the concerns our customers have expressed regarding the functionality and general user experience of the new lobbyist system. Also plan to discuss my proposal to utilize the services of a contract application architect or application developer over the next 6 to 8 weeks to help implement those system enhancements and to help create detailed user manuals related to both the lobbyist system and the FDS system after those development efforts are completed. We also anticipate that this IT resource will focus on improving the FDS system's interaction with the district's Lightweight Directory Access Protocol, or LDAP, as the new FDS e-filing system experienced significant problems syncing with the LDAP during the May 2018 FDS filing season, which unfortunately interfered with the ability of current district government employees to use their dc.gov usernames and passwords to access the new FDS system. This is a problem we simply must resolve if the 2019 FDS filing season is going to be successful, because unfortunately it did kind of drag out throughout the period of time that people were filing their reports last year. I am unaware of a permanent fix to that solution, or fix to that problem. Lastly, to improve the responsiveness and effectiveness of our technical support and customer service efforts, we plan to augment Octo's staff during FDS and LRR filing seasons by retaining additional experienced IT customer service personnel who will be available to troubleshoot and resolve issues as they arise. In addition to Octo's staffing efforts, which unfortunately were inadequate to address the volume of technical service support requests we have received for the new systems, we plan to retain 3 customer service specialists through the pipeline contract to assist BEGA's customers during the next quarterly LRR lobbyist filing season in April and the FDS filing season in May. Depending on the level of success achieved by those additional resources in April and May, we would continue utilizing those services during the July lobbyist filing season in fiscal 19 and the October and January lobbyist filing season in fiscal 20, while adjusting the staffing level up or down as needed.
And
Go ahead.
we have sufficient funds in our O-type funds to cover that?
We do.
It's a good use of the O-type funds.
I can't imagine a better use. I mean, I honestly can't.
That was my question, yes.
Yes, we do have sufficient funds.
I have a request. If you guys could do a Survey Monkey on both the FDS filing and the lobbyist, I think it would give us a lot of good feedback and let us know really where we are.
Absolutely.
Madam Chair, do you agree?
Yes.
It should be noted that although constructive criticism regarding the logistics of our rollout is well warranted and taken to heart, many users have complimented both BEGA and Octo staff for providing high-quality customer service for their questions and concerns since January 1st. I think the biggest problem is the volume and the amount of turnaround time that it took to get the help. We've also received favorable feedback from some users who felt that the new system constitutes a marked improvement over our old lobbyist system, and we plan to build upon those successes to provide a more expansive, favorable experience for the rest of our customers in the days and weeks ahead. After repeatedly asking Octo in vain to prepare a visual training guide for the new lobbyist system, They apparently did not have the bandwidth available to do so without negatively impacting their ability to process technical support requests from our users. My frustration with the rollout probably peaked last week when I tried to walk a lobbying client through the system and help her create an activity report, but was unable to figure out how to do so myself. Thus, I bit the bullet, rewatched Octo's training webinar, and took detailed notes before spending a good bit of time navigating around the system. While taking notes, I realized that I would probably absorb the concepts better if I took some screenshots during the webinar to provide greater context to my notes, and I took even more screenshots from the time I spent navigating through the system. Eventually, I realized that my notes could probably serve as a basic foundation for a visual user manual for the new system, and I have shared that very rough draft resulting document with the board for your review.
I have not had a chance to look at that, but all I can say is you all should be prepared to address this at the oversight hearing, and ultimately it's not Octo or anyone else. It is OGE's filing system. And ultimately, you all are responsible for it, and I hope the response to questions you get is we have learned from this, so things like manuals and trainings will be accomplished before the system rolls out for active use.
Absolutely. We addressed those. There were several questions posed in the performance questions, and I did try to take pains to answer them at length and provide as much detail regarding what happened and our plans for moving forward as possible. Here's an updated chart of the report filings to date split between registrant type. There are 431 activity reports that have been filed. The majority of those have been filed by lobbyists as opposed to clients. There have been 370 registration reports filed, but approximately looks like about 40 of those were 2018 registration reports. There was some confusion about whether lobbyists had to re-register for 2018 in the new system, even though they had been previously registered in the old system and paid. And I think out of an abundance of caution, some users went ahead and registered in 2018 and in the new system, and we're working with Octo and our old vendor on a case-by-case basis to make sure that nobody has to pay the registration fee twice.
Speaking of that, the data that was in the old system that was shut down so that lobbyists couldn't get the two confused, is that now available?
Yes, it was, I guess, when I gave instructions for the old system to be shut down, I really only wanted it to be shut down for input purposes, not search purposes. And staff took a very broad interpretation of my instructions, erring on the side of caution and shutting the whole thing down. When I realized that was the case, I provided additional clarity. And so the search functionality in the old system is available again. It was probably only down for a couple days at most. To provide additional context, it should be noted that we received 447 registrations during calendar year 2018 versus only 39 registrations to date for calendar year 2019. We also received 379 activity reports during the most recent filing season in July 2018 versus 431 activity reports to date for the first quarter of fiscal 19. We are working with Octo to gain insight into possible causes for the reduced number of registrations that have been accompanied for some reason by an increase in activity reports. It is possible that customer frustration, coupled with public awareness of the lenient enforcement position we have articulated, may have played a role in reducing the number of 2019 registrations filed thus far. However, we need to keep a close eye on the situation due to the potential impact on our budget that would result from a reduced volume of lobbyist registration fee payments. Non-confidential investigations, case number 18-0002F, N. Ray Antoine Wilson, Pursuant to DC Official Code, Section 1-1162.12A, we conducted formal investigations into whether the actions of former Chancellor Antoine Wilson and former Deputy Mayor Jennifer Niles, in connection with the Chancellor's daughter's mid-year transfer to an out-of-boundary school during the 2017-2018 school year, violated the Code of Conduct. We're close to wrapping up the language of a negotiated disposition with the Chancellor. We'll discuss that in greater detail during the executive session. Second case is the related case 18-0002F, in re Jennifer Niles. We are proposing a negotiated disposition with Ms. Niles that will be presented to the board in closed session. And the third case, 18-0006P, in re Jack Evans, is formal investigation into allegations that Councilmember Evans violated the Council Code of Conduct, is currently stayed. And that concludes my report.
Thank you, Director Wolfenbarger. All right, I'll now open the floor for opportunity for public comment. Remind everyone that you have 3 minutes. Do we have Mr. Syndrome? No. Sure, yes, ma'am. Sure.
So I am Valerie.
I'm sorry, come forward.
Actually, yeah, come forward.
I only need 1 seat. Thank you. Okay, thank you. Hi, I am Valerie Jablow. I'm a DC resident and a DCPS parent, and I am here to express my support of Brian Flowers, who has kindly undertaken what may be an investigation of a complaint that I registered with his office on June 15th about a possible unregistered lobbying group called PAVE, or Parents Amplifying Voices in Education. I'm here to register my concern anew because it has been over 6 months since I registered my complaint, and I appreciate whatever his office is doing as far as this goes. His most recent communication to me was at the beginning of January, where he said that his office had not made a decision yet on this, and that's great. But I wanted you to be aware that as we enter budget season, there will be lots of parents approaching council members and advocating for their schools. The inherent way in which this is done is unbalanced. PAVE has paid staff members, and they recently completed a week of advocacy at the council for School Choice Week. And I have some handouts here that I wanted to give to you, showing a picture of PAVE, what appears to be PAVE staff members meeting with David Grosso in his office. This was from an email that David Grosso's office sent out talking about activities his office was involved in. This is inherently an unequal situation. It's very difficult for me as a member of the public and a DCPS parent to go to the Wilson building just to advocate for anything, much less bring a whole bunch of other parents with me. PAVE brings resources to this that PTAs don't. There are no paid staff members for PTAs. There's no paid staff members from ward education councils going to the council to advocate for either the ward schools or individual schools. So I just wanted you to be aware of the urgency that I, as a taxpayer and a DCPS parent, feel about this, because it really does hurt parent advocacy when a group with paid staff members brings parents to the council and it looks like it's parent advocacy, but it's not. And it's not to put down what they do. I think they do good work. This is not about the fact that they do what they do. It's about the fact that it's equating me going to the council, or people from my school's PTA going to the council, or people from a ward education council going to the council. It's really hard. This is really hard work. As you know, there's always these drop-down and drag-out budget fights, and I just wanted you to be aware of how important I think this is to me as a taxpayer and a DCPS parent, and how appreciative I am that Mr. Flowers took this up. But I do feel that there's a certain urgency that I wanted you to be aware of. I didn't know if you wanted to have, this is a list of what PAVE has done recently, as well as the picture itself. And I'm happy to give it to you. So,
Sure, you can
thank
make sure that, Mr. Flowers has it. I will say I do not, first, thank you, for bringing this to our attention. I do not believe that this is a public investigation, at this point. So we will get an update from Mr. Flowers in executive session.
Okay.
But thank you for raising this issue.
Thank you.
Any other public comment? Hearing none, I move that we enter into executive session to discuss ongoing confidential investigations pursuant to DC Official Code Section 2-575B, to consult with an attorney to obtain legal advice and to preserve the attorney-client privilege between an attorney and a public body pursuant to DC Official Code Section 2-575B4A, to discuss personnel matters including the appointment, employment, assignment, promotion, performance, evaluation, compensation, discipline, demotion, removal, or resignation of government appointees, employees, or officials pursuant to DC Official Code Section 2-575B10, and to deliberate on a decision in which the Ethics Board will exercise quasi-judicial functions pursuant to DC Official Code Section 2-575B13. All those in favor of moving into executive session, please signify by saying aye. Aye. Any opposed? All right, the time is now 10:57. We are in executive session. We will start with OGE. The time is now 12:28. We are back on the record. We have two matters to report out. Case number 1031-017, in re Jennifer Niles. The board has reached a public negotiated disposition, which will be published on the BEGA website within 24 hours. The second matter to report out is case number 1702-001, in re Danielle Metters. The board has reached a public negotiated disposition, which will also be published on the BEGA website within 24 hours. Our next meeting is March the 14th, beginning at 10 a.m. We are now adjourned.
Noon.
Oh, it's noon?
It's noon on, because I have a 10 a.m. monthly management meeting that day at the DC bar, and so you guys, I think, graciously agreed to put it off till noon on March 14th.
With that correction. All right, this meeting is adjourned. Thank you.
Thank you.